Warm greetings from A.Mahalingam, TwinTech Academy Chennai. I take this great opportunity to welcome our today's program, all the participants and speakers, respected Mr. D Samuel Abraham, sir. Just I briefly mentioned about 2 lines about TwinTech Academy. TwinTech Healthcare Academy is a unit of TwinTech Academy Business Management Solutions, which is a registered and private limited company and functioning for the last 5 years. An institution engaged in offering practical and implementable solutions in the areas of healthcare education, management training, management consultancy, and counseling. On a case-to-case basis, TwinTech Academy also offers solutions, services in several other sectors. So far, TwinTech Academy organized more than 400 programs and few healthcare projects too. As part of our ongoing process, we are having an important healthcare legal session by our Mr. Samuel Abraham. Just 1 second. Mr. Samuel Abraham serves as a senior HR and legal advisor at the highly prestigious Christian Medical College, Ludhiana. Previously, he was with CMC Vellore many years. 3 decades of experience in both government and private sector organizations. An expert in hospital management, law, and HR. An excellent communicator, faculty in various B schools, and writer too. He used to write various journals, papers on healthcare legal aspects. He also written various books. The books are displayed here, and more details about his books and publications available in the given website. Over to our speaker, Mr. Samuel Abraham, sir. Over to you, sir.
Thank you very much for the detailed introduction. I am overwhelmed by the presence of all the participants today. I am so happy to share my knowledge in this very vital area. I want to thank the TwinTech Healthcare Academy for organizing such a very nice, wonderful webinar today. Now, briefly, I want to give an introduction as to why we are organizing this speech today. Their main reason is there are many confusions among the medical practitioners and hospital administrators about the new Consumer Protection Act 2019, and they are very much eager to know the difference between the Consumer Protection Act 1986, which was notified in 87, and the new Consumer Protection Act 2019. So what is the way, what are the ways which are very remedial or useful for medical practitioners? Whether the new law is easier to follow, or they put some hurdles for the medical practice or hospitals. That is our main concern. Even though we are talking, I am going to talk about Consumer Protection Act 2019, I will concentrate more on the portions which are on medical practice rather than the portion about other consumers who are being dealt in the act. So I will broadly discuss about the various provisions. After discussing the new act, I will discuss about what are the new provisions which were not there in 1986 Act. Number one. Number two, is it favorable to us? Number three, how to avoid litigation in the new act. Before going and discussing the new Consumer Protection Act 2019, my audience are a mixture of persons, administrators, doctors, and people holding various type of occupations. So first I will explain about certain doctrines so that my subsequent talk about this subject will be easily understood. So to introduce this one, slide number 1 please. I will talk about the Act 1986 for a brief period. Mr. Mahalingam, first slide please.
Yes, sir. Yeah.
Yes, sir. Slide is not visible.
No, Mahalingam. We
Oh,
could
it's
not
not
see it.
seen.
Black screen இருக்குங்க.
Just one second.
Okay.
இனிஷியலா வந்துருந்துச்சு. இப்போ
Yeah, yeah.
Sir, நீங்க carry on பண்ணுங்க, நான் வரேன்.
Okay, okay. Now, initially, in 1986 Act also, it did not include medical practice under the Consumer Protection Act. It never included. It was talking about the services offered by a concern for a law of contract. The 1986 Act mentioned that all the manufacturers, goods, services, etc., plus services offered by an institution under a contract, if the service is not proper, deficient, etc., then the consumer can go for a litigation. Now, two very important things are there. I want to explain, then you can very easily understand. As I told you, 1986 Act has also not included the medical service offered by a doctor or an hospital, etc. Then you can ask me, sir, how these medical services and hospital services were brought under the purview of Consumer Protection Act? Main reason was, after the enactment of 1986 Act, various high courts gave various different type of judgment. Especially when a person filed a consumer suit before the civil court and he went to the High Court of Madras, the Madras High Court held that the services offered by a doctor under surgery or any treatment directly to the patient is not coming under the purview of Consumer Protection Act. It said that the laboratory services, equipments, diagnosis, etc., can be brought under the purview of Consumer Protection Act. In a contradictory way, National Consumer Dispute Redressal Commission Delhi held that if a service is offered for a contract or for consideration, certainly it comes under Consumer Protection Act. In the two cases, Metropolitan Hospital case, you can go and search in the net also, Cosmopolitan Hospital case, which is emanated from Kerala state. The National Commission held that, thank you very much, held that any service offered for a contract is coming under the purview of Consumer Protection Act. Okay. Now, the dispute cross trial came to the Supreme Court of India finally. And the Supreme Court of India in 1995, in November, held that, please listen to me very carefully, when a person is taking treatment and getting a service from an hospital or a treating doctor, by payment of a fee, professional fee for him or to the hospital, it comes under the purview of Consumer Protection Act. So, not that the parliamentarians brought this medical service under the purview of Consumer Protection Act. No. Our legislators never brought this under the purview of Consumer Protection Act. Please understand, the Supreme Court of India in the Indian Medical Association case versus VP Shanda and others in 1996 brought this service under the purview of contract and under the purview of the Consumer Protection Act. So, in the legislation, there is no problem. But the interpretation of the Supreme Court only, it started this issue. Now you can ask, sir, so what is the advantage of being brought under the purview of Consumer Protection Act? Now, cross appeals are there in the Supreme Court. Indian Medical Association hired a very high-profile lawyers to represent that these services, medical service, should not be brought under the purview of Consumer Protection Act. It may affect our profession. Our right to practice freely will be restricted because of this. So, vehement arguments were there, but finally, the appeal was decided against the Indian Medical Association in favor of VP Shanda and others. So, VP Shanda filed this case in Hyderabad against the deficiency of service caused to her husband. So, there are, and others, there are so many other parties are also there. So, in 1995, end November, it was decided from 96 onwards, all the issues, deficiency of service, they came under the purview of Consumer Protection Act. Now you can ask me, so what is there? After all, it's a court. No, it is not a regular court. Next slide, please. There's a vast difference between a regular court and a tribunal constituted under a law. Please listen, again, I will repeat it. All the civil and criminal courts are constituted as per the provisions of the Indian Constitution. They are subordinate to nobody. They are sovereign. You can see the district court, session judge, additional session judge, high court judges, Supreme Court judges, all their it will be the court name will be there. No government will be there. Government is subordinate to the court because these courts are constituted as per the Constitution of India. But listen to me very carefully, my friends. There are court-like thing, body, forum, constituted as per a law enacted by the parliament or legislature. These laymen will call it as a court, but an advocate will not call it as a court. Their systematic civil procedure code will not be followed in a court established by a law. Now, the Protection Act, the Consumer Protection Act, creates 3 tribunals which are not regular court. Main difference is, next slide please, main difference is any petitioner to a civil court has to pay stamp duty. If I want to claim 5 lakhs from Mr. Mahalingam, I have to pay nearly 7.5% of the 5 lakhs as a stamp duty to a civil court. But tribunals are there which we call quasi-judicial, for which we need not pay any stamp duty. This These tribunals are established by an act of parliament or legislature where a small fee is paid. For example, 5 lakhs I want to claim from Mr. Mahalingam, I have to pay 7.5% and advocate fees, etc. If I want to claim 5 lakhs from an hospital for deficiency of service, I need not pay any stamp duty because it is not a regular court. It's a tribunal. Some civil people will be there, one judicial man will be there. It is 50%, 50%. Shortcut methods are there to dispose the cases. A delegated authority is given. No original jurisdiction, no inherent powers for them. They will dispose the cases within a limit of delegation only. Whereas civil courts and criminal courts are having hidden and unexpressed powers for them. We are not going to explain about that. So in a tribunal is constituted for the welfare of a class of people. Debt relief tribunal. Industrial tribunal is constituted for the labor. Labor court is not a court. Labor court is a tribunal constituted as per the provisions of Industrial Dispute Act. CAT, Central Tribunal. SAT, State Administrative Tribunal. In one way, the tribunal is called administrative forum, where certain type of disputes can be disposed and no stamp duty need to pay. Now, listen to me. Because the Supreme Court brought the medical service under the purview of Consumer Protection Act, the patients need not pay any stamp duty. They have to pay a small fee. I will explain. Up to 5 lakhs, only 200 rupees they have to pay. If it is a civil court, 5 into 7.5%, nearly 35,000 they have to pay. Now it's only 200 rupees. Up to 10 lakhs, from 5 lakhs to 10 lakhs, 400 rupees. More than 10 lakhs to 20, it is 500 rupees. Now listen to me. Because of this only, many patients claimed huge amount from the hospital and medical practitioner under the ground of deficiency of service. Now, why it was brought under the purview of Consumer Protection Act? Why Supreme Court has done that? They say that if the patient is able to pay a fee for the services offered by the hospital, it comes under the law of contract. Now you can ask me, what is the principles of contract? Very simple. It is all preliminary discussion I am giving. Then we will go to the provisions of that. Now, what is the principles of contract? Listen to me here. A sends offer and proposal to B. B considers that and he accepts to pay consideration to A. For example, I am a patient. There is an hospital situated in my place. I am visiting the hospital and signify myself that I am interested to take treatment in the hospital. While I am subjecting myself for the examination in an hospital, it is implied contract that the contract is on. Now the hospital says, for this service, you have to pay this money. I am paying the money. The contract is effective because hospital accepted my proposal that you have to check my body. Your doctor has to examine my body. The contract is on. And I have paid the money properly and correctly with the correct denomination. I expect a standard care from the hospital or the medical professional. When I feel aggrieved that the services are not given properly, I can file a complaint, which is called complaint, not a petition, complaint before the consumer forum. Ordinarily, we say consumer court, it's a forum actually. It's a tribunal. Now you understand, suppose I am in Madras. I want to travel to Vellore. I am going to the central station. There are scheduled rates, scheduled train, etc. specified. I am going to the counter and I am informing them I am interested to go to this card party through this train, this class. They give me the ticket. The moment I pay the money, the contract is on. And I am permitted to be carried by the train. And once I reach card party platform, I am expected to stay only 1 hour there. After that, the contract is off, completed, fulfilled, and my stay there become unlawful after 1 hour. Now listen to me very carefully, gentlemen. There is a contract. I paid the money. There are many implied contracts. I am in Saidapatti, Chennai. I am standing in a bus stop. Auto comes. Just I say Paris corner. I will not talk to anything. We have not discussed anything. We do not have any terms of contract. And he takes me to the Paris corner. I pay the money, maybe 200 rupees or 300 rupees. The contract is completed. Now listen to me. When I pay the money correctly, I expect a standard care performance. And the moment he takes me to Paris corner and I am not willing to pay the money, it's called breach of contract. Now I paid the money, but in between he stops the auto and asks me to get down. He asked me 200 rupees to put petrol for the auto or gas for his auto. I gave it. But in between, he stopped the auto and asked me to get out. Now I paid the money. The other contracting party has defaulted the terms of contract, which we call terms of contract. Listen to me very carefully. When I am purchasing a car, I am taking the car, new brand, I am driving it. After 10 kilometers, I find there is no radiator. It's a terms of contract. The car company failed miserably. I can get a new piece of car because the major terms of contract is violated. So the same way you can imagine, in a contract, party A sends offer or proposal to B, and B reciprocate, accept and reciprocate. Consideration means, in simple English, payment. Consideration means money, payment, or promise to pay. B promise to pay A full consideration. So 3 aspects are there in a contract. There must be an offer. I am willing to take the contract. In day-to-day affairs, we are getting newspaper, we are taking milk vendor, we are taking a bus, we are taking an auto, we are taking a taxi, we are traveling in a train, etc., etc., etc. 99.9% in our day-to-day life, we are undergoing implied contract only. Only 1% there will not be any contract. Our parents are investing huge money on us, but we are not reciprocating. A is giving money, materials to the children, but the children never reciprocate equally. The contract is called donation. It's a donor. It's a gift. Now you listen, apply this formula. Now the Supreme Court says the service offered by the hospital and medical professional became a contract. So automatically the patients are empowered to approach the consumer protection forum where they need not pay any cost. That is why we are having so many number of cases. That is why we suffer a lot. But in the new act, we are going to see what are the changes. So whenever I am discussing this new act, I will also talk about the old act and show you the difference. Then in the conclusion, we will see how it can be prevented in the course of lecture. Next slide please. Now, in the act, they say complaint. Complaint means here, in our area of discussion, it is the patient. Patient can make a complaint. If the patient dies, his parents, his relatives, his legal heir, if it is a minor, a guardian can file a complaint against the hospital or the doctor or whoever may be. So normally complaint is about the service offered by the doctor and the hospital. Complainant means any person who took treatment in an hospital, or if he dies, or if he is insane, if he is a minor, if he is not able to act independently, his guardian can be a complainant in a case. Consumer, those people who are paying for the treatment in an hospital or a doctor, they became consumer. Now, there are two exemptions are there. Suppose in the state of Tamil Nadu or state of Karnataka or state of Kerala or whatever the state, I am the patient. I am going and taking treatment. Everything is free. And I am taking treatment. They take care of me. But the operation or any medical treatment, there is a major deficiency of service. The question is whether I can come under the purview of Consumer Protection Act. The answer is no. Why? I told you about. It is a gift given by the state of Tamil Nadu, or state of Kerala, or state of Karnataka, or state of Punjab. They have not received any money from me, but they offered service to me. Just like my parents, it is a gift. But however, under the vicarious liability, when the state is maintaining an hospital and the doctor has done something which is not proper, the state is responsible because it comes under welfare of the state. So I can go to a civil court because there is no contract between me and the state of Tamil Nadu. There is no contract. No consideration passed from me to the state. State offered me free services. That's why if there is any deficiency of service, I have to go to the civil court and I claim compensation. I have to pay stamp duty. Suppose you are a very poor man. You cannot pay stamp duty, but there is a deficiency of service given by this government hospital. There is a provision in the law that such complainants, such petitioners, they can go to the civil court and they can file a proper petition that I am not able to pay the cost. If it is awarded against the state of Tamil Nadu, at that time court can deduct the stamp duty from the award, from the money. And if it is allowed, I need not pay any stamp duty, but I will be called petitioner in a civil court. My name is a complainant in the tribunal consumer forum, but my name will be petitioner because I am paying stamp duty to the civil court. Number two, one government hospital. Number two, any hospital which is offering the service fully 100% free of cost, it is not coming under the purview of Consumer Protection Act. If I had some agreements, I have to go to the civil court. There is another question from you. Suppose in an hospital, 50% patients are seen and given treatment free of cost. 50% they are charging. Will it come under the Consumer Protection Act? Yes. It will come under the purview of Consumer Protection Act. So now you understand who is consumer or who is the rights of the consumer. Defect. It is defective goods manufactured by a company, which we are not interested now in our deficiency. Says if there is a standard of care, if standard of care is there, if your hospital, your doctor has given a service which is below the standard of care, standard of care, this is the standard of care, but your doctor has given 6 months, he has not followed each and every procedure, then there is a deficiency of service. We call deficiency of service. And we also discuss about the degree of deficiency. Simple negligence, gross negligence, GROSS, gross negligence means the doctor has not followed many of the procedures to be followed. Then contributory negligence. Composite negligence. The doctor writes a name of a medicine and the nurse interprets in a wrong way about the medicine and asks the patient to purchase. And when it's injected, adverse effect is there for the patient. It's called composite negligence. More than one person is there in the negligence. Criminal negligence, fully knowing that it may cost injury to a person. If a doctor is doing that, it's called criminal negligence. So, simple negligence degree is very, very less. Gross negligence, composite negligence, criminal negligence, and contribute negligence conducted or done by the consumer himself, patient himself. We are going to discuss about that later. Now, product liability. In this act, section 2, product liability, which it denotes the industry. We are not going to discuss that. Next slide, please. Now, product manufacturers, product seller, product service provider. Third is very important. An hospital and doctor are coming under product service provider, and this is very, very important for us. So, all other things, all other points are related to manufacturing, suppliers, commercial things. We are very much worried about the product service provider. But the law expects that we have to follow a standard care. You may ask me, sir, what's the definition for a standard care? The standard care is nothing but if a patient comes to you for a particular disease, a deformity, and you are giving a treatment, medical service, other services, nursing, paramedical equipments, etc., etc., etc. Every facility is being given to some extent. That service is equivalent to another hospital if this patient went to that another hospital. It should be a tandem or it should be equivalent to the service offered by your peer group in another hospital. That we call normally a standard care for a layman's understanding. So the moment your service is less than the standard care, then deficiency of service comes, and depending upon the degree of deficiency of service, the award of compensation is given by the court. Next slide, please. Now, this new act has 3 special features which were not found in the previous act. That means 1986. Central Consumer Protection Council, Section 3. State Consumer Protection Council, Central Consumer Protection Authority. 2 councils, one central government, they have formed a council to supervise the services and the products quality all over India. Now, the same way, every state, there is a State Consumer Protection Council with all the members, and they are looking after the preventive type side of the products. It includes service also. Now, third is very, very important, my dear friends. Central Consumer Protecting Authority. This authority is headed by a Director General of Police, DGP, in the Delhi level. And if there is unfair trade policy or any spurious items is mixed in a product, or if any hospital is practicing which and according to the principles which are not acceptable, complaint can be made to the Central Consumer Protection Authority, and that authority is having penal powers to investigate, find out, and punish the institutions. So we have to change all our equipments, etc., up to date. Only then we can escape from these people. In the district level, the district collector is the Consumer Protection Authority in every state in India, and the Central Consumer Protection Authority will be overseeing and supervising the activities of this council and its working. Now, next slide, please. Let us see, I am going to discuss about one by one, that is for your knowledge, very easy to understand. My dear friends, in 1986 Act, they have formulated 3 tribunals, 3 courts. We call it layman's language, I will call as a court. Strictly, it is not a court, it's a tribunal. Okay, forum. So, in the 1986 Act, they call District Consumer Dispute Redressal Forum. Okay, 3 members were there. Now it is called District Consumer Dispute Redressal Commission. More powers for that. It's a vast difference between a forum and a commission. Now, section 28, there is a president equivalent to the district judge. 2 members are there. The jurisdiction, friends, before the forum had jurisdiction of 20 lakhs. Listen to me very carefully. Before, in every district, there was a District Consumer Dispute Redressal Forum functioning, and it was headed by a retired district judge. The jurisdiction, pecuniary jurisdiction we call. Pecuniary means monetary jurisdiction is any complaint up to 20 lakhs, a consumer or a patient can go and file a case. Let's see here, 1 crore, up to 1 crore, the patient can claim compensation in the district level. It's a vast change. So the patients now need not go to the higher court, State Consumer Dispute Redressal Commission. They can complete their work in the district itself. So hospitals and doctors should be very careful not to give any room for compensation, awarding compensation, because before it was 20 lakhs. Suppose somebody in Salem, if he want to claim more than 20 lakhs, he has to go to the State Consumer Dispute Redressal Commission, Chennai. But now, up to 1 crore, he or she need not come to the state level commission. Now, suppose I am the consumer, I am the patient, I am filing a case, and I got 10 lakhs award, compensation to be paid by the hospital to me. Within 45 days, if I am not satisfied, I can go for an appeal. Now, listen to me very carefully. In the old act, both parties can go for an appeal. Now, here listen, the last deposit of 50% of awarded sum. I will explain to that. If there is an award of 10 lakhs against any hospital or a doctor, the law says any party against whom award of compensation is given in the buyer forum, they have to deposit 50% of the award sum. In 1986 Act, it was only 15,000 rupees to 25,000 rupees. Very easy. The hospital, the doctor can pay this money, get a receipt and file an appeal. The patient need not pay any deposit because there is an award against me. So I have to pay 15,000 to 20,000. But now you listen here, deposit 50% of the awarded sum. So if it is 10 lakhs, I have to pay 5 lakhs. If it is 20 lakhs, I have to pay 10 lakhs. If it is 50 lakhs, I have to deposit 25 lakhs. It is very, very, very difficult for the hospital as well as the medical professional, because a lot of money is being deposited. I do not know whether I will win in the appeal or not. This is the commission in the district level. Understand that. Next. State Consumer Dispute Redressal Commission, section 42. Here listen, there's a change. President, 4 members. Now jurisdiction before 1986 and 86 Act, it is up to 1 crore. Now you see here, up to 10 crores in the state level we can complete. Now all the patients who are aggrieved can complete their job within the district level and state level. They need not go to the national level. Up to, before it was 1 crore, now it is 10 crores. Appeal time 30 days. Here also deposit of 50% of awarded sum. So if the award 5 crores is awarded, I am the hospital, I am the patient, I am the doctor. If I want to file an appeal, if 10 crore is awarded or 5 crores is awarded, 2.5 crores I have to deposit in the state. It's very difficult. Before it was only 50,000 rupees I paid before the State Consumer Dispute Redressal Commission, Hyderabad, for an appeal, and I got the appeal won by me, and we withdraw the deposit money. It is only 50,000 rupees. Now it is 50% of the award given by the state consumer dispute redressal. It is very, very unfavorable to the hospital and the doctor. Next slide, please. National Consumer Dispute Redressal Commission, Section 53. Look carefully. President, 4 members, more than 10 crores is the pecuniary jurisdiction. There's a power to review. Before it was not there, the power to review the judgment. Set aside ex parte orders. If a party was not heard by the forum for the commission, the aggrieved party can ask for a set asiding petition. I will explain. The 2 parties are there. Suppose the patient filed a complaint. Notice is being sent to the hospital and the doctor. But 3 or 4 times we tried, but they were not represented by an advocate or by a party. Now the court, the forum, the commission gives a verdict of 15 lakhs or 15 crore. For example, I am telling. Now, the hospital again, after receipt of this one, shocked and surprised, and take the copy and file a petition application. Please set aside the order issued by you. We want to participate and contest the case. So if you are filing that, the forum, the commission can set aside and order for a fresh hearing. After hearing both the parties, then they can give an award. Here, appeal time 30 days. Here also, the problem, deposit of 50% of awarded sum is there. Now, to whom we can appeal against the orders of National Consumer Dispute Redressal Commission? Only one court is available in India. It is called Supreme Court of India. So suppose I fail in National Consumer Dispute Redressal Commission, I can go to the Supreme Court of India. Next slide, please. Now, the difference between 1987 Act and 2019 Act. For easy discussion, I put a very easy tabular. Sir, in 1986 Act, there is a consumer forum in Vellore, Madras, Trichy, all the district. There was no mediation cell. In this new Act, Section 74, every consumer forum, after receipt of this case, they will refer it to a mediator. The mediator is empaneled by the commission. For example, in Madras, if there is 3 district forums are there, district commission, and state commission is also there. So the moment they are receiving a complaint and send a notice to the hospital and doctor, after receiving both the parties, they will send this to a mediator appointed from the empanelment by the president. And a single mediator who is trained, he is a retired judge or any qualified person as a mediator approved by the commission. That man will be there, and you can, both the parties will be mediating, and if it is successful, they will sign an agreed settlement. That settlement will be sent to the commission for approval, and they will give a final order as per the settlement. If it is a settled case, no one party can go for an appeal because both the parties agreed for a settlement. This is called mediation cell, newly introduced in this act. That's why we are discussing the new act now. So if you fail, if they fail in the mediation, then the same will be sent to the Consumer Protection Court. So after that, the forum, the commission we'll go into the matter and give a award of compensation or dismiss the complaint as there's no ground for that. So disposal. So initially, when there is a complaint, both the parties will be referred to a mediation cell in the new act. Second, at present, the consumer forum cannot review any order. Suppose the forum gives a judgment, award, they cannot change it. Now the new act says power of review. Suppose a party asks for review by pointing out certain mistakes, some defects, then the same commission can review its own order. It's a new provision found. Next, very, very dangerous, deposit amount for appeal. You have to pay the deposit percentage before appeal. Before, the amount was very, very less. Now it is 50% of the awarded money. Now, new act, Central Consumer Protection Authority to supervise and see the activities. Now, before it was not there. Next, prevention and punishment of spurious goods. In the 1986 Act, there is no penal action. They can give an award, that's all. And a forum without any teeth. Now, this commission, that's why they named as commission, will act as a civil court as per the Civil Procedure Code, and they can also declared as first-class magistrate to punish any manufacturers who has done some, they have produced some spurious goods and they can be imprisoned. So that's also one of the very important difference. Pecuniary jurisdiction changed from 20 lakhs up to 1 crore. From 1 crore to 10 crore. From 10 crore to above. Product liability. This is also new thing, new concept, that if I am producing a goods, particular goods, I am liable if it is very defective. So far, it was not there. Endorser section. Endorser. In the TV program, you can see many goods are advertised. Many VIPs are showing the product. So, Emu Koli, for example. When the Emu season was there, all the film stars were recommending Emu Koli, Emu Hen. So now, the law says, if you are endorsing a goods which is very spurious, which is not in a standard way, you can also be liable for payment of compensation. So any film star, any actresses who are recommending any product which is defective can also be filed suit against them and award of compensation can be given against them. Now, cause of action is very, very important. Please listen to me. So far, listen to me very carefully. This is very important. So far, an Assam man comes to CMC Vellore or Chennai for taking treatment by paying a fee in the Apollo Hospital or CMC Vellore. If he is aggrieved, he can file a complaint before the forum within which the hospital is situated. Suppose he is taking a treatment in Nagarcoil district in a private hospital. He is from Delhi. He has to file the complaint in Nagarcoil court, not Delhi. If I am coming from Nagaland, taking treatment in CMC Vellore, I am aggrieved that the services are not good, I can file a complaint in Vellore Consumer Dispute Redressal Commission, not in Nagaland. But the but is very, very important. The new act says the cause of action, the complainant can file a complaint from his usual residence. That means an hospital situated in Chennai, if the patient comes from Delhi or Nagaland, that complaint can be filed in the court of Delhi or Nagaland. This hospital has to represent before that court. It is very, very difficult for the hospital to engage lawyers in various corners of this world. So This is a very, very serious concern for the hospitals. The last one is very, very dangerous. Please listen to me very carefully. Please. No second appeal. I will put the section also. Listen to me very carefully. If I am a patient, I am filing a case against an hospital in Chennai in the Consumer Dispute Redressal, District Consumer Dispute Redressal Commission for an amount of 15 lakhs. The award is given and the hospital is not ready to pay, they want to contest. In 1986 Act, the hospital can pay 15,000 rupees and file an appeal before the State Consumer Dispute Redressal Commission in Chennai. That commission also endorsed the findings of the district forum. No, you have to pay this money. Then the hospital can go for an appeal before the National Consumer Dispute Redressal Commission, Delhi. But, very strong but, in this act, no second appeal is possible. So only one appeal and the order comes to a finality. You cannot go anywhere. Again, I will repeat this. This is very important. You are residing in Chennai. You are in a hospital in Chennai. Some patient has filed a complaint against you. Before the, listen to me, State Consumer Dispute Redressal Commission, and up to 10 crores they can give award. They gave an award of 5 crores. Now you are in hospital. You want to have an appeal. Out of the 5 lakhs, you have to pay 2.5 crores and get a deposit, get a receipt and file an appeal before the National Commission, National Consumer Dispute Redressal Commission, Delhi. Suppose the National Commission says 5 crores is correct. No more appeal. It remains, it attains finality as per the new act. But as per the old act, you can go for National Commission. If you are not agreed, if you are not satisfied, you can go to the Supreme Court. But now the new act says only one appeal, no second appeal. Please understand. Next. Next, yeah. Now, is medical service exempted in the new act? I am telling you, no. It continues because when this act was passed, many parliamentarians, many common people, many doctors, Indian Medical Association represented the ministers and begged for exclusion from the Consumer Protection Act. And they also assured. But the problem lies not with the legislators, MPs or MLAs. The problem lies with the Supreme Court, which has held that as long as it's a contract, it will come under the purview of Consumer Protection Act. That's why new act has not exempted the medical service, health service from the purview of Consumer Protection Act. Interestingly, day before yesterday, I received a judgment copy from the Kerala High Court stating that medical services are also continued to be under the purview of Consumer Protection Act. So be assured that you should be very careful. Now, what's the balance time? What I am going to do. Now, what is the remedy for us? Next slide. This is the penal action which we are not interested. Next slide. Provisions which are unfavorable to the hospital. If you are having paper, you can write down. Deposit for appeal increased from 15,000, 25,000 to 50% of the awarded money. Cause of action changed from the hospital jurisdiction to the area where the patient resides, and no second appeal possible as per section 73. These 3 areas are not favorable to the hospital or medical practice in India. Next. Now, I want to complete this lecture with a very good positive note, what we are expected to do. Please, this is very, very important in this program, in the lecture program. Having discussed each and everything about the Consumer Protection Act, etc. That's okay. It's okay. You are informed about the dangers. Now, what's the remedy for that? You may ask me, sir, you have closed the lecture with a very, very pathetic note. No. I am going to discuss about what can be done next. Next slide, please. How to avoid litigation in a consumer. Now, you have to follow Bolam test. Very often I am talking about Bolam test and polythrow test. Now, what's the meaning of Bolam test? He's a very old man. He went to a hospital, Frayne Hospital Management in London in 1952. He had some nervous problem. The doctors is a small size state-owned hospital. Every state they are having a hospital, Frayne Hospital Management. Now, there are 6 or 7 doctors working in that hospital. When this old man, he is 72 years, when he approached the hospital for a nervous problem, a few doctors opined that we can give ECT for this man by a manual method. Another set of doctors opined, no, we have to give some anesthesia for this man, otherwise he cannot tolerate the pain. They are divided into 2. What procedure to be allowed? Now, after the final discussion, the group which recommended physical method, they won the race, and the old man was subjected to this procedure for the first day. Physical method, without giving any drugs. First day it went uneventful. When he came for the next procedure, next week, when they are giving this exercise, his femur bone was broken. And he filed a case against the hospital. The hospital resisted, saying it is a practice after all. It will happen in the 100 cases. A few cases may happen because physical method is also approved and practiced by a section of doctors in England at that time. It went to appeal and cross appeal, went to the Privy Council of England, which is considered to be the Supreme Court of Great Britain. There, the judges carefully gone through the nature of the case, and they want to save the medical services offered by the doctors because we cannot penalize the doctors also. But they found that before giving treatment to this man, the hospital did not get any consent and they did not explain about the risk factors contained in the procedure. And they, by a precaution to help the doctors, they lay down 3 tests. Gentlemen, if you are following these 3 tests, then you can defend your hospital 100% as per law, because this Bolam test is also followed by all over the world, including our Supreme Court, High Court, and every consumer forum. They recognize the Bolam test case, and they recognize that if the doctors are following, it is enough. The Supreme Court has declared that we are not bothered about the result of the patient after the procedure or after the operation. We are not bothered because it is not in the hands of the doctor. And you cannot compel a doctor by a halter. You cannot put a halter on the around the neck of the doctor and ask them to give a proper or a particular service. No. Whatever the services the doctors and hospitals are giving, it must be fulfilling the Bolam test. And if the hospital is fulfilling the Bolam test, no court can give any award against the hospital. Now we are going to see what are the tests. First test, duly qualified test. That means, as before touching a patient, please convince yourself whether you are duly qualified and you are duly having experience in that particular branch of medicine or not. The moment you are not convinced, you are not qualified or you are not convinced about that, you are qualified but you are not convinced to give treatment to a particular patient, don't touch the patient. Now, the duly qualified test is having some conditions also. For example, I am telling you, I am a OG doctor. Sorry, I am an MBBS doctor in Chennai. A lady comes to me in an advanced stage with complications arising from her pregnancy. There are many specialists in Chennai, in OG area. I am not a OG, I am a MBBS. I can divert this lady, ask her to go for a specialist. After doing some first aid, if possible, if required. This is duly qualified test. I am working in Mahunda Hospital, which is situated in the central forest area of Assam. No other hospital is available there. 100 kilometers, no hospital. Only forest. I am an MBBS doctor. Same type of patient comes to me. Here I should not direct the lady to some other hospital because it is not tenable. She cannot reach the hospital. Whatever I know, I have to give the service to the lady. Here in this place, I am duly qualified. I think listeners can easily find out the difference, my explanation. So before every profession, as per the Supreme Court judgment, every profession, there is a legal sanction to practice. You have completed MBBS, MD, but unless you registered in the Medical Council of India, you cannot practice. So there is a legal sanction for you, but however, you should convince yourself whether you can do it or not. The Bar Council of India gives license to me to practice any court in India, but I have to convince myself whether I can take a case which involved in constitutional matter. I have to convince myself whether I am competent or not. It is called competency test. Number 2, listen to me very carefully. This is the heart of our discussion. Due care test. It has 3 areas. Number 1, once you decide to select a patient, follow the procedures which are being given or practiced by your peer group according to the textbook or medical journal explained for that particular disease. Every day, every time, you have to follow the procedure without giving any gap. Even if there is any gap of 1 or 2 days, you have to justify that why you are not given any treatment to this patient. Is it observation or have you given any drugs for observation, etc. You have to explain without, you cannot give a statement that there are so many patients I was not able to concentrate. No excuse. But once you take the patient, follow the procedures, write for the test. According to the test result, you have to take a medical opinion and you have to follow it immediately. So follow the procedure is one first point under due care test. How you are going to prove before a court whether you have taken a due care? I am telling I have taken due care, but I have to prove it. By how? These are the 3 areas. I have to show medical records to display that I have followed the procedure correctly. Second test, whatever the procedures I have followed, it should be recorded in the medical records of the patient. That's called procedures recorded. See, very experienced doctors before 90s, they never write anything in the medical record because at that time, they were considered to be God of the patient. Patient never questioned the authority and the decision of the doctor. But now, the completely changed. Your patient became a consumer. and he is purchasing the service from you, from his money. So you are responsible for that. So you have to record it. And another very good suggestion I'm giving you, when you are prescribing some medicine, you have to see whether the patient is taking the medicine or not. If there is any failure, you have to make it in the record. There are some more learned consumers and patients. If you are prescribing 5 medicine, they will take only 3. And if you are asking why you are not taking the other, sir, my son and daughter are living in USA and they say these medicines are very injurious, so I have not taken. Immediately you have to make it in the medical records. It's called contributory negligence on the part of the patient. It should be recorded, and the court in India will support this. Third, informed consent. Informed consent is a separate session I have to take describing about the consent. You have to take a consent from the patient, which is called to be the terms of a contract. The patient comes to your hospital, he takes treatment. The consent form is the terms of the agreement. You has to do all these things. For that you are receiving the fees. As I told you, when I am purchasing a car, the terms of contract is there. Warranty, guarantee, etc., we call terms of contract. When a patient is coming and taking treatment in your hospital, you have to inform him each and everything. From the time being, I am telling, first you have to give the procedures, the nature of operation, name of the operation, what you are going to do in medical term and layman's language. It is very, very important. Second, what are the risk factors? In Bolam test we learned what are the risk factors found. Don't say the name of the risk, but you have to give some examples. There are so many court cases there, we don't have any time to talk about that. But however, when you are writing the risk factors, please give some examples. So, risk of rubella explained to him is not a proper information. Risk of rubella explained to the patient. It's a medical term, an ordinary person cannot understand. But you have to say, newborn will born with some deformity in the birth. They will not have any eye, they will not any have ear, etc. With the example, you have to give a risk. And you should not write all medical terms, but you have to tell layman's language also. So first of all, procedures name, layman's language, risk factors, possible advantage, and after the operation, what will be the permanent solution, permanent risk factors. In ortho, what will be the permanent? He may think that after the operation he can walk like a Amir Khan and he can dance like Prabhudeva. But you have to explain, even after the operation, there will be some problem in walking. So these risk factors must be explained to him. Cost, who is going to operate, all these factors form a proper consent with proper date, signature of the patient. If the patient is unconscious, relatives. If the relatives, what's the relationship? And doctor with his full name with the rubber stamp as per the latest law. No scribbling. You have to signature, full name and your registration. So it is all informed consent. Next, choose a procedure which is being followed in location and time. I am a doctor, full-fledged doctor registered under the Medical Council of India. I am practicing in Chennai. Before practicing Chennai, I was in Nigeria, maybe more than 25 years. Now I opened a clinic in Chennai, and whatever the ailments, I start giving some treatment and medicine which I prescribe to the Nigeria people. And the methodology and the procedure followed there, I should not do that. The law says you have to choose a procedure which is in practice in your location and around your location. Next, very important, you have to select a procedure which is practiced in 2022. A procedure which was successful in 2010 in Chennai cannot be followed in 2022. That's why location, time. So you have to choose one procedure which is being practiced in your location, your peer group, and in the relevant time. This we call Bolam test. You have to follow that. After this Bolam test, there is a polythorough test we call. What is the meaning of polythorough test? That means there was a case in Europe. There is a small boy, 2.5 years old. He comes from a rich family. He lost both of his parents. His grandmother was looking after this boy. He had seizure. That means he cannot, his respiration is a problem for him. So he was admitted in an hospital and a doctor was appointed, nominated. A nursing was also nominated for him. This 2.5 years old boy was playing on the bed, going here and there, but immediately he will have some respiratory problem, he will fall, and after that they will do some procedure and he will regain. Now they are not able to give any ventilation for this man. So 2 times it came and he escaped from this problem. When third incident came, the boy died. And the grandmother filed cases against the hospital. And it was argued very, you have to understand, listen very carefully, then only you can find out the outcome. In the court, 8 doctors were called. And a question was put by the judge. What is the general practice for such patient? And majority of the doctors gave opinion. Will you put ventilator for this boy? Majority says, usually we are not putting any ventilation because it is very difficult to calm the boy unless we give some sedation. So we are not giving ventilation. This would mean majority of the people says ventilation is not recommended. Now second question was asked. Suppose ventilation was given. Is there a chance of saving his life? 5 doctors opined there is a chance for saving the life of the boy if you gave ventilating. 3% negative. Now, as per the Bolam test, the doctors have not done anything wrong. Generally, we will not put ventilation. But the opinion of the 5 people says, if you gave ventilation, there is a chance of saving the boy. The court declared that if there is such issue, the doctors has to come to a logical conclusion, valid, backed by reasoning. So that is a judgment in polythorough, P-O-L-I-T-H-R-O, polythorough case. Next slip. Next. Now, as a last effort from me, I have taken some materials from the American books and I found that 9 principles to be followed, and if you are following these 9, there is an ample chance we can win very easily the case. Number 1, win rapport. Sir, believe me, in many hospitals, rapport is the question. The doctors, nurses are overburdened. Too many work, heavy work, and because of the heavy work, they don't have a proper language and they use certain language which will offend the patient. It is very difficult, I know that. Medical fraternity, they find it very difficult to work in a situation where, COVID situations, etc. Very, very difficult. Very, very difficult. And the patient, many of the patients, they don't understand the situation. They repeatedly ask many things, which the medical fraternity will find it very difficult to answer. Sometimes they shout back. So rapport, measured talk is very, very important in a medical setup. So many of the consumer cases are filed because the patients want to take revenge on the hospital because they feel that they are aggrieved and they were not given ample chance. I tell you, it is very difficult, I know that. And the patients also, from their point of view, no patient is coming for a honeymoon here in an hospital. They find it very difficult to pay. If they are paying for a honeymoon, they are very happy to pay. They never bothered about the purchase cost, etc. But if they are coming for an hospital, they feel that it is a very big burden on their monetary side. So remarks, rapport dealings is very, very important. Second, rationale. What is the meaning of rationale? Rationale is a set of reasons in a large or a logical basis for a cause of continuous action. Actually, rationale is a set of reasons. See, when you are giving a treatment to a patient, follow the rational principle. 3, record. I told you, record is the savior. I have read a medical book in America authored by American people. He says, it is the medical records which win the case. I repeat, according to the doctor has written a book. And in one word, he says, it is the medical records which wins the case where you are able to prove that you followed the Bolam test correctly. Remarks. When you are talking, it should be measured. In one of the famous hospital, a woman came, maybe 35 years, for HRT procedure. And the doctors prescribed some medicine. And they were treated in the OPD. Then after 1 year, she came again. She was tested having a breast cancer. And the senior doctor was there, junior doctors were there. And the patient was also there. Patient's husband also sat there unknowingly, unconspicuously. Now the junior doctor, out of curiosity, asked the senior, doctor, is this because of the drugs we gave, this cancer has come? This is a question he asked. The senior says, not possible. But however, it is noted by the patient and her husband, who is a lawyer. Immediately, there were set of writ petitions, cases against the hospital. It was running more than 10 years. You should have a measured talk. Don't talk. Measured talk. You should be very happy, smiling, but in words, you should be very careful. It is very difficult in the practice situation. Very easy to give a lecture, but it is very difficult, but you have to practice. It is wrongly written R/S. That means any doctor before prescription, they put a slip RS before writing a medicine. Now, the connotation here is, at those days, the doctors will give a direction to the compounder how to make a mixture of medicine to be given to the patient. That's why it started from there. But today, I am going to talk to you, before writing a drugs, any medicine, you have to write it with full application of mind. There are many cases decided against the hospital and doctors because of excess prescription. Kunal Saga case, where 13 crores were awarded against the hospital, Amri Hospital, Calcutta. 13 crores. 6 crores and 77 lakhs was awarded. With the interest, it came to 13 crores. It is a historical case where Depo-Metral was prescribed overdose. Instead of prescribing 1 milligram per 1 kilo, they prescribed 2 milligram, that is 80 milligram, 3 times in a day. And it aggravated, and the Supreme Court gave this verdict. So when prescribing, please go to the net and check whether evidence-based or not. Right. Now, next, res ipso liquidator. Previous slide, please. Previous slide, please. Yeah, res ipso liquidator. I think time is there. Yeah, res ipso liquidator means don't commit physical injury. Res ipso liquidator means the patient need not prove the case. I was admitted for some problem in the right eye, but operation was done in the left. Many of the cases after operation, they leave a cloth or any instrument which we call res ipso liquidator. Be careful in dealing with that. Result, you are very much result, need not worry about the result. The court says if you are following the Bolam test, you need not worry about the result. As per the result, court is not giving any compensation. They are not bothered. They are bothering whether you follow the procedure correctly or not. Because result, nobody can give guarantee. Risk factors always have a risk. What will be the risk factors? You have to explain, and although almost always have a presence of mind keeping the risk factors in mind. Last one is respect. Respect the consumers. That is always important. Next. So with this, I think I want to conclude the discussion. 8 minutes are there. If there is any questions, you can type it, or you can also inform me what type of doubt you are having with this briefing. I think Mr. Mahalingam will have some idea about the questions. You can also send the questions to my email here, dsalegal2004@gmail.com. You can also contact me in my cell number. It is a matter of academic interest, I am telling you. I will be very happy and delighted to receive your phone call and receive your email in the address which you can write to me. If you want to physically meet me, you can meet me in the address I will give. Questions, I am eagerly waiting for that.
Dear audience, if any question, just type in the chat box.
It should not be one-sided. You can also participate. You can also offer your remarks. You can also talk.
Any queries? Any questions?
One more valuable time is there. Please come up with your suggestions. You can suggest for improvement of my talk. You can give me your frank remarks about the talk, how I can improve upon, what are the deficiencies, and you can also give me what are the new topics we can propose for new venture in the days to come. What are the areas you may require more light on that? Be frank, be participative. You are all very senior people.
The feedback link is shared by message. Just you can take 2 minutes and you can fill and send later on. And any question, just you can ask to the speaker or type in the box.
I'm Dr. Prakash from Star Health Insurance.
Yes, sir. Yes, sir.
My appreciations to Mr. Samuel for the very brilliant and very affirmative talk. I really enjoyed every moment of your presentation. I just want to have one clarification.
Yes, sir.
What is the legal binding power for the insurers by an act of subrogation?
Okay. Sir, very good question, sir. Very question, very intelligent question. I will explain. Please, participant, please listen to me. See, as per law, I talked about the principles of contract. But unfortunately, you can, I will give an example, then I will come to this area. I am having a cornfield, and there were too many bats are coming and eating away my corn. I fixed an automatic catapult which will throw away the stones in all directions. It is fenced. There was a bystander going in that area, and one stone hit him and he died. Now, every offense, if it is done with criminal intention, we call mens rea, then it comes under the category of criminal offense. If there is an offense, but without mens rea, but caused damage to a third party, we call it law of tort. Again, I repeat, if my action has caused injury to another person without any mens rea, without my thinking, without any intention, I never thought that, but it is caused. This category of cases we categorize as law of tort, T-O-R-T. Now, peculiarly in an hospital treatment setup, it's very, very interesting to know that. I'm very so happy. There is a contract. The patient comes on a contractual term, and the hospital is ready to offer their best services. When they are giving their best services, as I told you in the Kunal Saha case, Dr. Sukumar Mukherjee is a very famous physician. He prescribed Depo-Metrol 80 milligram 2 times for 3 days for Anuradha Gunal Saha. Anuradha Gunal Saha was 45 kilos weight only. And when she was, before death, she was transferred from Calcutta to Breach Gandhi Hospital, Mumbai, where she died. Now listen to me, in every contract, there is a liquidated damage. That means maximum level a court can give under law of contract. So, as per the law of contract, they can give a compensation. But what happens in a hospital setup is, it surpasses the limit of law of contract. It reaches the domain of law of tort, where in every law of tort, only court will give the decision, and it is not under contract law, but it is under tort law. I will give an example. For example, only I am not finding fault with anybody. I am undergoing an operation, and due to some pressure of work, when before closing, they put some scissors or anything in my stomach and they close. The result, the consequence cannot be quantified in the principles of contract, because in the principles of contract, it's a limited scope for compensation. For example, I have to send 50 bags of basmati rice to a merchant. I promised, but I failed. So compensation will be within the 50 bags of basmati rice. Their cost, damage, transport, etc. only, not beyond that. So in commercial area, the law of contract, the defaulter breach of contract can be quantified and settled to the other party. But in medical practice, suppose a scissors or something is there, I die. My loss cannot be quantified under the law of contract. The courts comes in and they say it is their law, they give the compensation. So even if they are insured, the insurance company can give only very, very less money, but the balance normally the hospital has to pay, or the state of, suppose it is treated by a state, the state has to pay. If it is a government hospital, state of Tamil Nadu. In an hospital in Egmore, there is a woman hospital in Egmore, and there was a ROP for a premature girl. the girl lost both eyes, sight of the both eyes. They went to Sangarnetralaya, Aravind. They went to USA, but they say no, it cannot be done. 1 crore 39 lakhs was awarded in favor of this girl to be paid by the state of Tamil Nadu, by the Supreme Court of India. Now, this is arising not under a contract law, it arises because of tort law. So, insurance company cannot give this money. Amri Hospital also insured, but Kunal Saga case, only the hospital paid the money because insurance having a limit. They can cover only law of contract. They cannot cover the law, the compensation awarded under law of tort. I think I explained to you. Is it okay, sir, Mr. Ramesh?
Yes, sir, Dr. Prakash. Thank you so much, sir. Thanks for the clarification.
Is it very clarified? It is very clear?
Yeah. Certainly. You're just hit on the nail. Thank you so much.
Thank you. Any other questions? I am so eagerly waiting.
So I'm Dr. Jay Kumar, sir. Can I ask a question?
Yes, sir. Yes, sir.
Yeah. So I'm a anesthetist basically.
Okay.
Yeah. Today, I'm not doing anesthetist practice,
Mm.
but I'm running a daycare clinic in a periphery.
Okay.
Okay, in a panchayat. Okay, sir.
Okay.
So today I got a patient. It's a teenage girl who have consumed a phenol.
Okay.
Okay. So pre-corona season, I used to treat those patients. I used to give first aid and then refer them.
Okay.
So today I got a call. Actually, the patient was in the Omni van. Then the nurses came and told me that there was a girl who consumed the phenol. Okay, then I said, okay, you better go to GH because of corona, I am not utilizing all the spaces of my clinic. I'm just utilizing only 30% of the working area in my clinic.
Okay.
So this kind of scenario, so I have the facilities and then I have the capacity and then talent to treat the patients. But right now in COVID scenario, so I don't want to take risk. So I just refer them without examining them. Just taking the history, I just refer to the GH or the private hospital.
Okay.
Okay, in that case, suppose something untoward happened after they reaching the GH in that Namakkal or in some other private hospital. So am I comes under the contract or they might sue me?
Sir, I will give an explanation. Even if there's no law of contract, as per the law, any medical professional has to offer his service in an emergency where you need not get any consent at all. In an emergency situation, whatever possible first aid, you have to do it. In a case called Orchid Hospital, you can refer in the website also, Orchid Hospital versus the state of Delhi. In that case, there was an incident that the pickpocket stabbed the abdomen of a military man in the bus. When the military man wanted to prevent the pickpocket from cutting the bag of a woman. It was a huge rush in the bus.
Yes.
Immediately all the people went skelter. He was taken to the street platform and the bus was taken away. This man was lying in the road opposite to a clinic, and the doctor, anxiety, he came down, saw the bleeding man, and very coolly he went back, closed his door, and he started giving treatment to the patient. Now, after that, one of the clients, those patients who were waiting for him, took sympathy and took this man to Orchid Hospital. Now, the court gave 2 lakhs rupees fine against the single doctor near whose clinic this man was lying, bleeding profusely, for not doing first aid. As a doctor, you only know for the situation, what type of first aid can given to that patient who approached you in an Omni car. Certainly there will be a type of first aid to prevent the gravity of the injury. You could have done. If you know that there is a facility, there is a system, you can do it. Suppose you feel that no first aid is possible, nothing is possible for this patient professionally, you are within the law of India, no problem. That is left to you.
Oh,
But normally, as a
okay,
doctor,
sir. Suppose one more. Yes, sir. Please.
you can give more. They say no. If there is any problem, you can also give more liquid so that the gravity will be less.
Thank you, Dr. Jayakumar sir. And more details if you want, just you can contact Dr. Samuel sir over phone or saying, find out. There is one more question in the chat box.
Thank you, sir.
Is a deposit of 50% of awarded sum by hospital can be refunded if the hospital is not found guilty as per the complaint by a patient?
Very good question. Not guilty actually. It is not coming under guilty. But see, when the hospital is filing an appeal, they have to pay 50%. If they are successful in the appeal, then the deposit money will be given back to the hospital. For that, they have to dismiss the complaint.
Okay. Thank you for all the participants and our speaker, Mr. Samuel Abraham, sir.